Morning. We're going to start in just a minute. If for any reason you get dropped off the conference, just try to reestablish your connection. We'll just stop and do nothing until we get you back on. Likewise, if you can't reestablish your video connection, you can always call in. You've got a number for that. And we will start exactly at 10 o'clock since this is a public proceeding on YouTube, so that all of our thousands of viewers can tune in. And I'm obviously Judge Edwards. We have Judge Eisnagel and we have Judge Grosshands this morning. And it's now 10 o'clock. So we are ready to proceed now with case 18-3572, which is Thea Kovarik versus Carla Deloach and Deloach Bryant PL. If appellant would like something other than 5 minutes as rebuttal time, just let us know now and our marshal will set the clock accordingly. But is 5 minutes all right, or you want something
5 minutes is fine, Your Honor.
Right, then you may proceed when you're ready.
May it please the court. My name is Joseph Fryan. I represent the appellant Thea Kovarik individually and as mother of her 2 minor children. This appeal relates to changes to the testamentary documents of my client's now deceased father, and questions with regard to the manner in which such testamentary documents came in to being. Tragically, Thea had a long relationship with her father, had previously been the primary beneficiary under his testamentary documents. Within a short period of time, prior to his prior deaths, revisions substantially were made, and tragically, her father, who had psychological issues, took his own life. When this appeal initially was filed, it regarded both of the then defendants, the trustee defendants and the attorney defendants. The trustee defendants were addressed in counts 1 through 5 of the amended complaint. That issue has now been resolved. The issues before the court relate to counts 6 through 9 of the 3rd amended complaint. There are 2 primary issues being presented on this appeal. The first is whether the trial court erred in dismissing the 3rd amended complaint with prejudice. The second issue relates to a partial summary judgment that was entered in favor of the trust defendants initially, which appellees now assert is binding on any action for undue influence included within counts 6 through 9. With regard to the first point, the parties are in agreement with regard to the standard for dismissal with prejudice. And both briefs cite case law to the effect that the case should not be dismissed with prejudice unless the amendment privilege has been abused, there is prejudice to the opposing party, or further amendment would be futile. Appellee has not asserted the 2 first grounds, but rather now asserts that amendment would be futile. The appellee acknowledges the standard cited in my brief under undereducated foster children, that futility arises only when, and I'm quoting, it conclusively appears that it is not possible to amend the complaint to state a cause of action. Further, under the
Counsel, at what point do you reach that? You know, I mean, on it, is it the 5th amended complaint, the 7th amended complaint? At what point does the trial court, in your view, does the trial court no longer abuse its discretion when it dismisses with prejudice?
Judge, I realize the holding of the Dimmick case, which was relied upon by appellees, but the more recent case law stands for the proposition, I believe, that is not the number of the complaints that are filed, but rather whether it is satisfies the standard that there is no possible way for an amendment to occur. But within
Counsel,
that,
I mean, let's take that to its logical conclusion then. So if the trial judge looks at the case and let's say we're on the 12th amended complaint, but the trial judge realizes that the plaintiff could, make the proper allegations, but just continually doesn't. You're suggesting that the trial judge could never dismiss with prejudice?
Your Honor, I note that there are cases with 8 to 10 amendments. My suggestion, Judge, is that the substantive issue is whether a complaint can be amended. But with regard to this particular case, Judge.
No, counsel, answer my question first, right? So you're on the 12th amended complaint. The trial court realizes, based upon its knowledge of the case, that that the plaintiff could indeed make sufficient allegations, but on the 12th amended complaint still hasn't done it for whatever reason. How many more amendments must the trial court give?
Judge, I have not seen case law that addresses that specific point.
I'm asking you, counsel, what's your answer?
At some point, Your Honor, certainly significantly more than what we have here, the court may be able to draw that conclusion.
So it's not the rule. You're not suggesting that the rule should be simply the trial court can never dismiss with prejudice if the plaintiff could make sufficient allegations, right? That's not the rule you're suggesting.
Well, Your Honor, I'm quoting the rule from the appellate court, specifically when it says, when it conclusively appears no possible way to amend the complaint to state a cause of action. So respectfully, yes, I'm adopting that standard and I am urging this court.
So what I'm asking you is, counsel, on the 12th amended complaint, do you read that rule as suggesting that on the 12th amended complaint, the trial judge must still grant an opportunity to amend?
So, Your Honor, conceivably on a 12th amended complaint, there may have been issues that have arose that lead the court to the conclusion that the amendment is not possible.
No, counsel, you're fighting my hypothetical. Just answer my hypothetical. Because in this hypothetical, the plaintiff's counsel could make sufficient allegations, but because perhaps they simply don't understand the law or they don't understand the process, they haven't done it. Is the trial judge required to continue granting opportunities to amend? Yes or no?
Well, respectfully, Judge, the answer, I think, would depend upon the specific directions provided by the trial court with regard to the prior trust, and the standard would be as set forth in the existing case law. But in this case, Judge, this is only the second amended complaint as far as these appellees go. The initial complaint was admittedly a bare bones complaint due to the notice requirement, hired and filed in 180 days. These appellees were not a party to that proceeding. There was then an amended complaint, first amended complaint, motion to dismiss was filed by stipulation. We amended the complaint. There was one hearing between the prior judge. The focus of that judge's ruling was that we should change the structure of the complaint to plead separately with regard to each count the different testamentary documents. That was filed. That is the third amended complaint. This is now before the court. When opposing counsel filed their motion to dismiss, requesting greater specificity, they did not even request a motion to dismiss with prejudice. So, respectfully to your hypothetical, talking about 12th amendments, in this case, this is only the second time the appellee has had an amended complaint raised as to them. They were initially joined in the first amended complaint. The second amended complaint the court dismissed, and the third amended complaint was brought before the court. So even within the parameters of that particular hypothetical, Judge, we should be allowed to proceed and to amend our complaint and make reasonable effort to do it. It is highlighted by the fact that discovery was ongoing during this whole period of time with substantial discovery.
How long has the case been pending, counsel? At the time of dismissal with prejudice, how long had the case been pending?
Judge, I have to look. I think it was 13 months.
My recollection's a little longer than that.
Okay, you could be right, Judge. I'm looking it up now.
So what was going on with discovery that took, you concede that it was at least 13 months. I thought it was 18 months.
Okay. So, Judge.
How long does discovery take in order to be able to make sufficient allegations in your complaint?
Judge, there were, number one, there were depositions of the parties. There was paper discovery, interrogatories requested to produce that were exchanged. There were then parties there were depositions of the attorneys involved in the drafting of this, a portion of which occurred after. I would also note, as cited in my initial brief, Judge, that in cases involving undue influence, the court knows that these are presented in a circumstantial manner, that a presumption is created in acknowledgement of the difficulty in discovery of these cases, because as the cases say, the decedent is no longer with us and the party is against the person who is being accused of impropriety. So this case was appropriately proceeding. There is a basis for further amendment to the complaint, and that's what we're asking for.
What is, just out of curiosity, what is the basis for the amendment?
The basis for the amendment would be twofold, Judge. To number one, plead more specifically the facts relating to the filing of the preparation of the will, the trust that is now in dispute with regard to this, the communications between the parties and the attorneys that occurred with regard to it, and also with regard to the actions of the trustee with regard to the administration of the trust, and specifically with regard to communications. I'm sorry, I said trustee. I meant the attorney defendants. With regard to communications with the decedent regarding an agreed upon budget that the father had agreed that was going to be paid for a specified period of time, criticism of that budget, a change in that budget based on alleged tax considerations that created disharmony between the daughter and her father, with the attorney trustee asserting that a house which had been purchased with the father holding a mortgage had to be foreclosed, even though it was owned by a trust and the beneficiaries of that trust.
Did you put the trial court on notice of any facts that you could allege that would demonstrate undue influence?
Your Honor, our focus was on the Carpenter presumption and the three specific elements of the Carpenter presumption.
Counsel, I'd like to ask you about that presumption. One of the elements is a substantial beneficiary.
Yes.
At what point are you alleging that the attorney became a substantial beneficiary?
She became a substantial beneficiary in three ways. When she was initially included as, she and her firm were initially included as trustee, but then also with the final amendment and the amendment immediately prior to that, where she was given an opportunity, where she received personal property, all personal property.
As so that was the final, the 2015.
As well as the amendment prior to that time.
So the 2015 trust and then any documents after that.
Right.
So prior to that, you would not consider her a substantial beneficiary.
Judge, I believe she received increasing amounts to the degree she was appointed as a fiduciary or a firm was appointed as a fiduciary to administer. Under the case law, that would qualify as a substantial beneficiary. When she became the beneficiary of personal property, and I cite the definition in 119, or what is included, statute 119, what is included in personal property, and she was another alternative basis for that. And finally, Your Honor, she received the opportunity to buy the decedent's house, not at fair market value as represented, but rather as of 706 value, i.e. the value that of a lower appraisal as testified to that is included on tax form 706. Consistent with that, there was testimony, although not filed on the summary judgment issue, timely filed on the summary judgment issue, where appellee actually paid an extra $400,000 for the house. So there are
just so I'm clear, you rely solely on the Carpenter factors, the Carpenter presumption, correct? You're not independently trying to establish undue influence otherwise.
That is correct, Your Honor.
Okay. So now that we've narrowed it to that, what historic facts do you allege in the third amended complaint to establish active procurement of the will at issue?
So active procurement, Your Honor,
What are the facts that you allege that would sufficiently establish, if true, active procurement?
So the facts relevant to active procurement include that appellees recommended the attorney who ultimately prepared the final revision of the trust, number one. Number two, they communicated and provided input with regard to the drafting of that. Number three, the courts have recognized a series of signposts, is the words that the courts use that are suggestive of a factual dispute with regard to the presence of active procurement with regard to that. Those signposts, which are actually referenced in their motion, although no evidence was provided in support of that, was isolation of the decedent, the disparagement of his daughter and her husband by the appellee, the secrecy of the transaction involving the revised estate plan, and the renewed psychological issues that were being addressed, that had arisen with Dr. Levine prior to his death.
Can you only just speak to the allegations in the third amended complaint? Just tell me what in the third amended complaint you argue sufficiently alleges active procurement.
Maybe Judge Eisnagel, if you don't disagree, we could let him do that in rebuttal since he only has 2.5 minutes left. So counsel, why don't you think of that during your rebuttal time, okay? All right. All right, counsel, are you ready for the appellees?
I am. May it please the court. So, Judge Eisnagel, to answer your question, there really are no allegations of active procurement in the third amended complaint. And the third amended complaint is curious in and of itself how it's structured. So there's a general allegation section, which are paragraphs 1 through 24, which essentially offer no real active information about wrongful acts. It's essentially an introduction section and description of some of the estate planning documents. You then get into counts 1 through 5, which are paragraphs 25 through 99, which are now dismissed. So to be clear, not only was the appeal dismissed as to the summary judgment, which was on counts 2, 4, and 5, But then Mr. Frine asked for jurisdiction to be relinquished back to the underlying trial court for a period of time. And when that jurisdiction was relinquished, counts 1 through 5 were dismissed. So procedurally, as we sit here today, determining whether or not there is a third amended complaint that could survive a motion to dismiss, or whether or not there's even an ability to cure that at some point moving forward, the actual allegations that even mention words like procurement, or which talk about purported conflicts, those are in the 5 counts that were dismissed. And when you get to the actual 4 counts that are against my clients, count 6 through 9, those are paragraphs 101 through 125. There's just 24 paragraphs for those 4 counts. And those 4 counts are pled in an extremely conclusory and non-factual specific manner. So understanding both Judge Weiss was examining this on a motion to dismiss, limited to the 4 corners of the complaint with the attachments, and we provided the court with our law on that. And given that you all are in a de novo capacity looking at the same third amended complaint, there are no allegations in count 6 or count 7 or count 8 or count 9 that remotely flesh out any cause of action against my clients, let alone even contain the buzzwords or the elements which Judge Weiss concluded were the only things that were in there, because they're in counts 1 through 5. And to give the court just a brief example of this, when you get to count 6 starts off by saying we reincorporate counts 1 through 99. Well, the general allegations are counts 1 through 24. Count 1 through count 5 or count 25, or rather paragraphs 25 through 99. So you start off procedurally with a complaint that wasn't framed properly and now essentially has information that has been dismissed and is moot before the court. In part of our brief, we addressed the concept of mootness. We included the Montgomery versus Department of Health and Rehabilitative Services case. That was a first district court of appeals case out of 1985. The mootness argument applies.
I just want to make sure I understand the argument you're making right now.
Sure.
You know, when I look at count 6, it appears that paragraph 101 re-alleges the allegations in quote contained in paragraph 1 through 99 above, as though fully set forth herein. Walk me through why that is insufficient to incorporate those paragraphs into count 6.
Sure, Your Honor. So typically, I'm going to say it's preferred pleading practice. Can I cite the court a case that says it's fully prohibited? But typically, you're not supposed to reincorporate in a new count another count. You're supposed to have a general allegation section.
Well, counsel, that might be a very good practice, but is there any authority for the proposition that if one does that, it is a nullity?
Well, Your Honor, I didn't cite any to the court, but here's why it becomes particularly important here. The counts that are being cited to as containing this predicate information have had 2 unique things happen to them that are different than most cases that you're dealing with a motion to dismiss. The first was summary judgment was actually granted on 3 of those counts, count 2, 4, and 5. So the court, in a well-reasoned order, determined as a matter of law and fact that there were no sufficient causes of action to move forward under those counts. And in fact, to the contrary, adjudicated them in favor of the trustees, which was in opposition to Mr. Frine's clients. And the second procedural development is they've all been dismissed. So I would suggest to the court,
why does that eliminate the factual allegations that would have been made in those paragraphs?
So with respect to counts 2, 4, and 5, to back up to the motion for summary judgment, they've been adjudicated. So if they've been adjudicated adverse to the plaintiffs, I don't believe there's any way you can go back and then rely on those for any other purpose beyond what they were adjudicated for. With respect to the court, when you dismiss a count like that, do you still get the benefit of the paragraphs that were within that count once you've dismissed it? Your Honor, I'm not aware of a case that says that's the case. Normally, when a count's dismissed—
Are you aware of a case that says it's not the case?
Your Honor, I'm aware of cases that stand for the proposition that a new complaint supersedes a prior complaint. So for example, if I filed a third amended complaint that left off count 2 from the second amended complaint, it wouldn't exist anymore. Would a dismissal act in the same way of a superseding complaint? I would argue it does. If you take a dismissal of a count, the count's gone just as if you filed an amended complaint and didn't include it. And so
I mean,
what we have
that seems like a highly technical result, right? Is there any authority in the rules or otherwise for such? In other words, you're saying, well, look, if count 1 is dismissed by the court, not only is that no longer a count against the defendant, but any factual allegations that were alleged are essentially erased by the dismissal.
So, Your Honor, I'm going to change your question slightly, because count 1 through 5 weren't dismissed by the court on its own. They were voluntarily dismissed by the plaintiff. And yes, if the plaintiff dismisses counts and then tries to rely on those same counts, which have now been dismissed, to justify other counts, yes, that would be a procedural problem that was of the plaintiff's creation. And that's been part of the procedural issue that's intertwined within this case, is that you had really the focus of the complaint and the allegations. So once again, I didn't do a percentage, but maybe 80 or 90% of the actual allegations within the third amended complaint, which are short on facts to begin with, those are all involved in counts 1 through 5, which 3 of which have been summary judgment out against the defendants, against the plaintiffs, and all of which have since been dismissed. So procedurally, we would suggest that does create an issue, number one. Number two, even if they still exist. So for purposes of our oral argument, procedurally, they're all live and to be considered. Once again, as Judge Weiss found, and as you questioned, and it's our position, none of those counts actually establish a genuine factual predicate for any of the causes of action alleged. And then really most importantly, for motion to dismiss purposes, all of those counts are precluded by the fact that the plaintiff had an adequate remedy at probate, which she did not pursue, which was largely based.
Counsel, I'd like to talk about that issue. There's a lot writing on this, that she had this adequate remedy. How, since she was not required to get notice, correct, under the law, because she was not a beneficiary.
Correct.
She could have filed something, but where do we find in the pleadings, on her complaint there that she did have awareness of this and therefore could have pursued this remedy? That's where I'm having a hard time making that connection.
So, Your Honor, that's, I think what the court's first of all referring to is the issue number one, which is someone who's not a beneficiary is not entitled to get notice of a will that's going to be administered in probate. However, the courts and the Florida legislature has provided a statute to file the caveat. And the caveat was discussed at length in Judge Weiss's order. And what a caveat allows is for someone who is concerned that there would be a will administered in the state of Florida without their knowledge, they can file a caveat. And then if that ever occurs, that person gets notice. And so the legislature has built in safeguard for situations in which someone who may not otherwise have been required to get notice because of their beneficiary status can still participate in the process.
But counsel, are there deadlines though for filing that caveat?
There are deadlines for filing the caveat, and the caveat can actually, the caveat's good for 2 years.
How can we tell from the pleadings when she had notice and whether or not the deadline had run for her to file her caveat?
So, Your Honor, the pleadings, interestingly, don't discuss that in great detail, except in paragraph 11 of the third amended complaint. The plaintiff says Hayford, who works for Deloach PL, is the co-trustee of the Leonard Trust, the designated personal representative under the 2014 will, and cause the initiation of a summary administration in that certain case styled in re estate of Leonard J. Levine deceased, pending in the probate division of the Circuit Court in Fort Orange County. So if we're going to read the third amended complaint literally and stick within its four corners, it identifies in paragraph 11 that there's actually administration action that's pending at that time. Not that it was completed, not that she was not given notice, but pending. And if you take that as true, then it would have been open and active at that time for the appellants in this case to have challenged the wills and the trust and the beneficiary intent of the settlor and the decedent in the probate action, because the case law is clear that it is the probate court that's supposed to determine these sorts of issues, these contests amongst beneficiaries or intended beneficiaries, and that absent fairly extreme circumstances, collateral attacks on a will or a trust are prohibitive. And the really only exception to that is when the appellant or the plaintiff had so been misled of the existence of the underlying probate matter that they didn't even know that there was an issue. So the case law that talks about very limited circumstances of fraud and concealment is not the fraud and concealment in preparation of the estate planning documents, it's the fraud and concealment of, for example, the death, or it's the fraud and concealment that will administration or probate matter had even been opened. Here, in the third amended complaint, there are allegations that talk about the date of death of Dr. Levine. There's an allegation in paragraph 11 that talks about a probate matter being initiated and pending. And there are no allegations to suggest that the appellates didn't know, didn't have an opportunity, were prohibited from filing a caveat. And with respect to the issue of futility, and getting back to Judge Eisnagel's question about how many times do you let a complaint get replayed? We know from the discovery taken in this case, and once again, the order granting the motion to dismiss was September 7, 2018. The case was filed on September 12, 2016. So from file to order, you're almost at 24 months. There was a fair amount of discovery within there. Your Honors, it's not contested that Ms. Kovorak, the appellant, knew her father died, went to the funeral, was aware that there had been changes to the will, and none of that is an issue, and none of that's curable in an amended complaint. There's no amended complaint, there's no fourth or fifth or sixth amended complaint that can be filed that will ever change those facts. And similarly, there's no amended complaint that can be filed which would add any evidence of procurement, because we know there isn't any. There's no amended complaint that can be filed that will somehow establish that
Counsel,
my client.
I guess I'll challenge what you just said. You said there's no allegations that could be made of procurement, quote, because we know there isn't any. I mean, how do we know that?
It's been adjudicated, Your Honor. So there were motions for summary judgment on counts 2, 4, and 5, all of which sought to set aside the 2015 trust amendment, the 2015 codicil, and the 2014 will or trust. They've all been adjudicated, and those summary judgments are not live anymore before this court. They were resolved on appeal through a settlement. They're never going to be unadjudicated. The plaintiffs attempted to have jurisdiction relinquished to the trial court so that they could get Judge Weiss to somehow withdraw his order adjudicating those issues, which he declined to do, and that order is part of our record on appeal. But they've all been adjudicated. And in his order granting summary judgment, which is also part of the record, Judge Weiss tracked through the deposition testimony of all of the principals. So Thea Kovorak, the appellant, her husband, Matt, my client, Carla Deloge, Sarah Hayford, Robert Wilkins, who was the individual who prepared the 2015 estate planning documents. There was no conflicting evidence on that issue. There was only evidence that no
Counsel,
such
we're-
efforts at procurement.
I'm asking about the dismissal, not about summary judgment. So, we're talking about whether there's conflicting evidence. I'm not sure that that really hits the nail on the head, does it?
Yeah,
I mean, all we're
it
looking
does,
at,
Your Honor.
all we're looking
Well,
at
in all
on
fairness-
dismissal is the complaint, right?
Yes, except if the question or the issue is, but we should have been given another opportunity to amend, because if we amended, we would have done X. I mean, that's the logical next step to why should you get another opportunity to amend. The issue regarding the adequate remedy of probate can never be fixed. I mean, that can never be fixed. That is a black and white issue, can never be cured. However, in considering de novo, whether or not the dismissal was appropriate, the court did consider whether or not further amendment would be viable. And when all of the facts have been placed before the court, albeit in part on a summary judgment motion, when all of the facts are before the court, and the court knows those facts and knows there are no active procurement issues, knows the testimony of the appellant, knows the testimony of my client, when the court knows all of that, the court is in a position to determine, okay, this third amended complaint is insufficient. This third amended complaint has these problems. Can it be cured? No, it can't. And in that circumstance, sure, the court can go beyond the four corners of the complaint, not to dismiss it, because the court is bound by the four corners of the complaint and the attachments in evaluating the dismissal, but the court can go beyond the four corners of the complaint in considering whether further amendment would be possible. And I would note to the court that in their brief, one of the complaints of the appellants was that our argument that the Florida statute that talks about if a lawyer prepares or is involved in a estate planning document, I got it right in front of me here, I'm sorry, 732-806, gifts to lawyers and other disqualified persons. 732-806 is cited in all of the first 5 counts. So as grounds to set aside each of those estate planning documents, the appellant cited the 732-806, which generally talks about a gift to an attorney who was involved in the creation of the estate planning document is void unless...
Does that set aside the entire document?
Does it set aside? It would certainly create a presumption. I think you would have to work really hard.
For the entire will?
Your Honor, to answer your question, no, I think it would set aside at most that limited gift, which in this case would be personal property.
So would that help the appellant here if they prevailed on that argument?
Well, here's the problem with that argument, Your Honor. There's an exception to the application of 732-806. And that is if the lawyer is related to the testator. And under 732-806-7B, a person is related under item 7B6 if it's a person who cohabitates with the individual. So
was that in the complaint, cohabitation?
So the answer is, we say it is, and I'll tell you where. So in the record, and it's in the 510 to 524 section, and this has to do with amendments to the trust documents. This is where my client, the lawyer, is given basically the right of first refusal for the home that they were sharing. And included within that is a section called intent. And instead, it's the intent of testator that this section apply so that my client can either buy the house or find a place to live. Does the document specifically say they are cohabitating at a moment in time? No, but can they be fairly read that way? Yes, and more importantly, all the transcripts in this case acknowledge that my client did in fact cohabitate with the decedent. So feudal amendment, you could never replead that to allege anything otherwise. And I've got 6 seconds left, Your Honor, and I will yield that 6 seconds.
Okay, you're actually 6 seconds over, but that's okay.
Oh no,
right.
I was counting the wrong way. So sorry.
All right. That's okay. All right, you have 2 minutes and 26 seconds for your rebuttal, so use your time well.
With regard to the adequate remedy at probate, it's important to distinguish that in this case, the two documents are a revocable trust, became irrevocable upon his date of death, which was fully funded, and a will. The will, only $75,000 or some amount less passes under the will. Everything else goes under the terms of the trust. As I've set forth in the Martin case on page 9 of my reply brief, if you accept the argument that we're precluded from collaterally attacking the will, that pertains only to assets passing under that will less than $75,000. The approximately $20 million in the trust is not subject to that. And this is specifically the point in the Martin case, which goes on to elaborate, there's too many differences between wills and trusts. This is not a flow-through will where all the money comes out and then goes into it. This money was already in the trust. So number one, on the adequacy of the probate remedy, even if we were to accept that, that would apply only to the portion, the $75,000 or less, passing under the terms of the will. Number two.
Counsel, why don't you address where you alleged active procurement?
I will, Judge. I'm sorry. I just wanted to get that covered first. Judge, in the third amended complaint, we alleged, beginning at paragraph 58, since at least 2011, Deloche, acting both individually and through Deloche BL, played an active role as confident advisors to Leonard in matters pertaining to his estate planning documents.
Counsel, isn't that pretty vague? I mean, those are pretty conclusory terms. Do you have any specific facts that would support active procurement?
We're talking now about the allegations of the complaint, Judge, or the...
Correct.
Okay. On the allegations of the complaint, I would ask the court to also consider paragraph 60, where Deloche became the exclusive party to communicate with Thea and Leonard regarding Leonard's personal desires and intentions pertaining to his estate planning goals and objectives, especially, and as those desires and intentions pertain to Thea. That would be at paragraph 60. Under paragraph...
Counsel, you're out of time. If Judge Eisnagel is satisfied with what he's heard so far, that's fine.
Thank you.
All right, then we will go ahead and adjourn, and we will be back at 11 o'clock for our third case. Thank you very much.
Thank you, Your Honor.
Thank you.